Procedural difference between an FIR case and a complaint case. In Part 1, we understood the meaning of an FIR and a complaint. Now let us understand the most important aspect, the legal procedure followed in each case. Although both relate to criminal offences, the legal procedure in an FIR case and a complaint case is entirely different. Understanding this distinction helps every citizen choose the correct legal remedy. We are proud to have crossed 1 lakh subscribers and received the YouTube Silver Creator Award. Thank you for your trust and support. Please subscribe free for more legal awareness videos. If you'd like to support the channel, you can become a member for 59 rupees or 119 rupees by scanning the GPay QR code on the screen. Now, let's begin today's topic. What happens after an FIR is registered? Once an FIR is registered under Section 173 of the Bharatiya Nagarik Suraksha Sanhita, 2023, BNSS, the police may commence investigation in accordance with law. The object of the investigation is to discover the truth by collecting lawful evidence relating to the alleged offence. During the investigation, the police may, depending upon the facts of the case and the applicable law, visit the place of occurrence, record statements of witnesses, collect documentary evidence, seize relevant articles or documents, conduct searches where authorized by law, obtain forensic or scientific evidence, recover stolen property or other incriminating material, arrest the accused where the law permits and the facts justify such arrest. Every investigation is expected to be fair, impartial, and objective. The investigating officer is expected to collect both incriminating as well as exculpatory material so that justice is served. The purpose of investigation is not merely to secure a conviction but to discover the truth. What happens after the investigation is completed? After completing the investigation, the police submit their final report before the jurisdictional magistrate in accordance with the provisions of the BNSS. Depending upon the evidence collected during investigation, the police may: first, file a charge sheet, police report, if sufficient evidence exists to prosecute the accused. Second, submit a closure report or final report where no offence is made out or where sufficient evidence is not available for prosecution. It is important to remember that the opinion of the police is not binding on the magistrate. The magistrate independently examines the material placed before the court and thereafter passes such order as may be permissible in law. What happens in a complaint case? The procedure in a complaint case is fundamentally different. Unlike an FIR case, the process begins before the magistrate and not before the police. The complainant files a complaint before the competent magistrate requesting the court to take legal action against the person alleged to have committed an offence. The magistrate then considers the complaint in accordance with the provisions of the BNSS. Examination of the complainant. One important feature of a complaint case is that the magistrate ordinarily examines the complainant on oath. Where necessary, the magistrate may also examine the witnesses produced by the complainant. The purpose of this examination is to determine whether sufficient grounds exist for proceeding further. This judicial scrutiny acts as an important safeguard against frivolous, malicious, or vexatious criminal proceedings. Can the magistrate direct a police investigation? Yes. In appropriate cases, and where the law so permits, the magistrate may direct the police to conduct an investigation. Such a direction is issued after the magistrate applies judicial mind to the facts and circumstances of the case. This statutory power ensures that a genuine complainant is not left without a remedy merely because the police initially declined to act. Can the magistrate issue summons directly? Yes. If, after considering the complaint, the statements recorded, and the material produced before the court, the magistrate is satisfied that sufficient grounds exist for proceeding, the court may issue process against the accused. Depending upon the nature of the offence and the applicable law, the court may issue summons or warrants where legally justified. Thereafter, the complaint case proceeds before the criminal court in accordance with law. Role of the police in both cases. This is perhaps the most significant practical difference between the two procedures. In an FIR case, the police play the primary role during the initial stage. They investigate the offense, collect evidence, identify the accused, examine witnesses and submit their report before the magistrate. In a complaint case, the court plays the primary role at the beginning. The magistrate first examines the complaint and decides the future course of action. Police involvement may arise later if the court considers it necessary and passes an appropriate order under the BNSS. Therefore, an FIR case is ordinarily police-driven during its initial stage. A complaint case is judicially supervised from the very beginning. This is one of the fundamental differences between the two. Does registration of an FIR automatically result in arrest? The answer is no. This is one of the most common misconceptions among the general public. Registration of an FIR does not automatically mean that the accused must be arrested. The investigating officer must exercise the power of arrest strictly in accordance with the provisions of law. The necessity of arrest depends upon several factors, including the nature and gravity of the offense, the available evidence, the possibility of the accused absconding, the likelihood of tampering with evidence, the possibility of influencing witnesses, other legally relevant considerations. The Supreme Court in Arnesh Kumar v. State of Bihar, 2014, emphatically held that arrest should not be made in a routine or mechanical manner merely because an FIR has been registered. The power to arrest is a legal power, but its exercise must always be fair, reasonable, and justified. Can an FIR be registered against an unknown person? Yes, if the identity of the offender is not known at the time of reporting the offense, the police may register an FIR against an unknown person. During the course of investigation, if evidence reveals the identity of the offender, the investigation continues against that person. This frequently occurs in cases involving robbery, theft, hit-and-run accidents, cybercrime, and other offenses where the offender is initially unidentified. Which case moves faster? There is no fixed answer. An FIR case may progress more quickly because the police ordinarily begin investigation soon after registration of the FIR. However, complex investigations involving numerous witnesses, forensic evidence, or multiple accused may take considerable time. A complaint case may initially proceed more slowly because the magistrate must first examine the complaint and determine whether sufficient grounds exist to proceed. Ultimately, the speed of either proceeding depends upon the nature of the offense, availability of evidence, number of witnesses, complexity of investigation, pendency before the court, cooperation of the parties. Therefore, it is incorrect to assume that one procedure is always faster than the other. Important practical difference. Remember this simple principle. An FIR primarily initiates a police investigation. A complaint primarily initiates judicial proceedings before the magistrate. Both are valid legal remedies. The appropriate remedy depends entirely upon the facts of the case and the provisions of law applicable to that case. Transition to Part 3. We have now understood the procedural differences between an FIR case and a complaint case. However, several practical questions still remain. What if the police refuse to register an FIR? What remedies are available under the BNSS? Can the High Court quash an FIR? What did the Supreme Court decide in the landmark Lalita Kumari case? Which remedy should a citizen choose in different situations? All these important questions will be answered in Part 3, the concluding part of this comprehensive legal guide.